There once was a time जब लोगों को उतनी ही आज़ादी मिलती थी जितनी उन्हें लॉ ने दे रखी थी। लॉ के दायरे से बाहर बढ़ के वो कुछ भी नहीं कर सकते थे। राइट्स बस उतने थे जितने कि ब्लैक लेटर लॉ में लिखे होते थे। लेकिन एक केस आता है और कॉन्स्टिट्यूशन का चेहरा ही बदल जाता है। राइट्स का इस कदर इंटरप्रिटेशन होता है कि आज राइट टू क्लीन एनवायरनमेंट भी एक फंडामेंटल राइट है। इंटरनेट को यूज़ करना भी एक फंडामेंटल राइट है। और आज हम सिर्फ एक केस लॉ की बदौलत से यहाँ पहुँचे। Hello everyone, I am Nivedita Raje and today in this session of Landmark Judgements, we are going to discuss Maneka Gandhi versus Union of India. This case is not only a landmark for the interpretation of Article 21, but it also gives an entirely new structure to look at Part 3 of the Indian Constitution. Prior to Maneka Gandhi's decision, Article 21 guaranteed the right to life and personal liberty only against the arbitrary action of the executive, but did not provide any protection from a legislative action. मतलब आर्टिकल 21 की जो फ्रीडम थी वो सिर्फ और सिर्फ एग्जीक्यूटिव एक्शन के अगेंस्ट अप्लाई होती थी। लेजिस्लेटिव एक्शन के अगेंस्ट आर्टिकल 21 एप्लीकेबल नहीं था। सिंपल शब्दों में जो अथॉरिटी लॉ को एनफोर्स कर रही है, एग्जीक्यूट कर रही है, उसके खिलाफ तो आप आर्टिकल 21 के हथियार को इस्तेमाल कर सकते हैं, लेकिन जो अथॉरिटी लॉ बना रही है, लेजिस्लेचर, उनके खिलाफ आर्टिकल 21 का प्रोटेक्शन अवेलेबल नहीं है। The concept of personal liberty first came up for consideration in A.K. Gopalan's case. In this case, the petitioner had been detained under Preventive Detention Act 1950. Communist leader A.K. Gopalan had been under detention since December 1947 since his sentencing under ordinary law. That conviction was subsequently set aside. On 1st March 1950, however, while he was still in Madras jail, Gopalan was served with an order made under Section 3 Clause 1 of the Preventive Detention Act 1950. That provision allowed the central government or the state government to detain anyone in order to prevent them from acting in any manner prejudicial to the nation, defense, foreign relations, national security, state security, public order, or the maintenance of essential supplies and services. Gopalan filed a writ petition under Article 32 applying for a writ of habeas corpus against his detention. Gopalan was prohibited to disclose the grounds under which he was arrested or detained because of Section 14 of the Preventive Detention Act 1950. This section also prohibited him from disclosing such grounds even in the court of law. He claimed that the order detaining him violated Articles 14, 19 and 21 of the Constitution, and the provisions of the Detention Act violated Article 22 of the Constitution. While rejecting the petitioner's arguments, the Supreme Court of India contended that Article 22 of the Indian Constitution is a self-contained code and that he was detained in accordance with the procedure established by law. The court also held that if the state takes away a person's liberty in accordance with the procedure established by law, that is, if the detention was done in accordance with the procedure of law, it cannot be said that it violates the provisions contained in Article 14, 19 and 21 of the Indian Constitution. A.K. Gopalan वर्सेस स्टेट ऑफ मद्रास के केस में सुप्रीम कोर्ट ने एक बहुत ही नैरो ओपिनियन को यूज़ करके आर्टिकल 21 को इंटरप्रेट किया। अगर उनके इंटरप्रिटेशन को सिंपली समझा जाए तो मतलब यही निकल कर आता है कि राइट्स और लॉ बस उतना है जितना किताब में लिखा हुआ है, उसके अलावा कुछ नहीं। और इन राइट्स को लेजिस्लेचर, एग्जीक्यूटिव बहुत इजीली वायलेट कर सकता है। बस उन्होंने प्रोसीजर एस्टैब्लिश्ड बाय लॉ को फॉलो कर रखा हो। In Maneka Gandhi's case, the meaning of the word personal liberty again came up for consideration in the Supreme Court of India. In this case, the petitioner's passport had been impounded by the central government under section 10 clause 3 clause C of the Passport Act 1967. Maneka Gandhi was issued a passport under the Passport Act 1967. On July 2, 1977, she received a letter from the Regional Passport Officer, New Delhi, asking her to surrender her passport under Section 10, Clause 3, Clause C within 7 days from the day on which the letter had been received. मिसेस गांधी ने एक लेटर के थ्रू रीजनल ऑफिसर से ये पूछा कि आखिर ये ऑर्डर जिसमें उन्हें अपना पासपोर्ट सरेंडर करना पड़ रहा है, ये किस रीज़न से आया है। However, the officer refused to provide any such reasons on grounds of interest of general public. Aggrieved by the arbitrary action of the executive in this case, Maneka Gandhi filed a writ petition in the Supreme Court of India under Article 32 of the Indian Constitution. She wanted her rights under Article 14 against the arbitrary steps of the Passport Office under 19 Clause 1 Clause A, 19 Clause 1 Clause G, that is right to freedom of movement, and Article 21, that is protection of life and personal liberty, to be enforced. Petitioner contended that the order passed by the administrative authorities is void and it takes away the petitioner's right to be given a fair chance of hearing to present her defense. Whether the fundamental rights are absolute or conditional, and what is the territorial extent of the application of such rights. Whether the right to travel abroad is protected under the umbrella of Article 21. What is the connection between the rights guaranteed under Article 14, 19 and 21 of the Indian Constitution? Determination of the scope of procedure established by law. Whether the provisions laid down in Section 10, Clause 3, Clause C of the Passport Act 1967 is violative of the fundamental rights, and if it is, whether such legislation is a concrete law. Whether the impugned order of the regional passport officer is in contravention of the principles of natural justice. The immensely important judgment was delivered on 25th January 1978, and it altered the landscape of Indian Constitution. This judgment widened Article 21 scope immensely, and it realized the goal of making India a welfare state as assured in the preamble. The fundamental rights conferred in Part 3 of the Constitution are not distinctive nor mutually exclusive. Any law depriving a person of his personal liberty has to stand a test of one or more of the fundamental rights conferred under Article 19. When referring to Article 14, the ex hypothesis must be tested. The concept of reasonableness must be protected in the procedure. The phrase used in Article 21 is procedure established by law instead of due process of law, which is said to have procedures that are free from arbitrariness and irrationality. It was held that there is a clear infringement of the basic ingredients of principles of natural justice, that is, odi alterum partem, and hence cannot be condemned as unfair and unjust even when a statute is silent on it. इस केस में ये भी क्लियर किया गया कि राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन एक ऐसा राइट है जो सिर्फ इंडिया में ही नहीं, इंडिया के बाहर भी सिटीजन्स के पास अवेलेबल है. Merely because the state's acts are restricted to the territory do not mean that fundamental rights are also restricted in the similar manner. जैसे हमारे देश में हमारे पास फंडामेंटल राइट्स हैं स्टेट के अगेंस्ट, उसी स्टेट के अगेंस्ट हमारे पास देश के बाहर भी फंडामेंटल राइट्स हैं. It is possible that certain rights related to human values are protected under fundamental rights even if they are not explicitly written in our constitution. For example, freedom of press is covered under Article 19 Clause 1 Clause A, even though it is not specifically mentioned there. Right to go abroad is a fundamental freedom guaranteed under Article 21, which can be curtailed using the procedure established by law. But it is exclusive and it is not covered under right to free speech and expression, as both have different natures and characters. Finally, A.K. Gopalan was overruled and it was stated that there is a unique relationship between Articles 14, 19 and 21, and every law must pass the tests of the said provisions. The case is considered to be a landmark case because it gave new and highly varied interpretation to the meaning of life and personal liberty under Article 21. Also, it expanded the horizons of freedom of speech and expression to the effect that the right is no longer restricted by the territorial boundaries of the country.